It's the appointed time and we have a quorum. Please invite the administration to come in to join us. Before they do, I would like to remind you that, if you have any direct or indirect pecuniary interest related to the topic, then please disclose. I would like to say that under 83A of the House Rules, I would like to make some declarations. I occupied a paid position of 2 travel agencies, and for 9 bodies related to the travel industry, I occupied an advisory role. Please refer to previous document. This document has already been uploaded onto the website of the LegCo. I am going to dispense with the introduction. The administration has given us response papers. Are you going to take us through it? Yes. In response to members' questions raised in the last occasion, I would like to give you our response. It's set out in paper number CP bracket 4735/17 to 18 bracket 02. I'll go over some salient points. First is about the registration fee of mainland inbound tour groups. We have already mentioned in the last meeting the policy intent of the charge. It's just that it's now reduced into writing. I'm not going to repeat it. The second one is about change of ownership or control. It's clause 34. Last time, members suggested amending the clause such that intentional change or permit to change the ownership or control without TIA's prior approval counts. And I would like to say that in relation to the definition of the wording of clause 34 bracket 1, controller, well, it is impossible for a licensed travel agent to change or permit a change of the ownership or control of his travel agent business without knowledge of such a change. And the offense in clause 34 bracket 1 is clearly targeted at licensed travel agents that knowingly make the above-mentioned change. So clause 34 follows Cap 218 Travel Agents Ordinance sections 16 bracket 1 and 48 bracket 2. Since these sections have been effective, we think that following the same practice will be suitable. The third question is display of travel agent license. A member asked whether a travel agent which is not open to the public but occasionally requests customers to come up would need to display the license. Well, this is just a statement of facts. If the travel agents choose not to open the premises to the public to carry on business, we will first look at all the facts of the case instead of just looking at a standalone occasion when customers are requested to come up. This doesn't automatically make the business open to the public. So we will look at the facts as a whole. In relation to display of information about tour groups, well, this is to assist members of a tour group and TIA investigators to identify vehicles arranged by licensed travel agents for transporting the participants of a tour group. This is basic and reasonable. This also assists the regulatory work of the TIA. In relation to the information display and the way in which the information is to be displayed, it will be prescribed by subsidiary legislation. We will consult the trade before we implement it. It may be done by way of administrative measure. In relation to clause 43 bracket 2 bracket A Roman 4 and 47 bracket 2 bracket A Roman 3, the legal advisor gave us some views in the last occasion. We suggest that the Chinese text will be changed to make the meaning clearer. So it will be changed to 申請人持有該局指明的機構發出有效急救技能證書或其他類似證明書，申請人持有而該證明書或證書由該局指明的機構發出。So that's all for the responses. Any questions? Perhaps I will start. That's in relation to registration fee. We hear of a spate of incidents related to mainland inbound tour groups, so there is a need to regulate them. So I would like to ask, under what circumstance will this be cancelled? Will this be withdrawn? Or is it the case that, well, even without any complaint and you have a very good record, you still have to follow the practice? And if, say, for example, in another market, say the Indian market, there are occasions when India inbound tour groups experience incidents such as participants are made to shop. So would the same apply to them? Is it the case that unless the problem is serious, the administration will not introduce such measure? Well, there is one paper tabled. This is in relation to the registration fee and its principle. They are worried that well, will it be increased substantially from $30 in the future? Well, the administration said that any increase will have to be done by subsidiary legislation. I see that when it comes to government fees, they will be frozen for quite some time, and then there will be a huge hike. So how would you deal with the increase of such fees? In relation to the registration fees, well, we actually had a discussion last time. Well, that itself is partly a regulatory cost, and I have already explained, but I will give you some information. In relation to the regulatory cost of mainland inbound tour groups, the Tourism Commission has spent a lot of resources on this. Say, for example, well, for the revenue, it accounts for 11% of the charge in the 2015-16 fiscal year. Regulatory costs them 41% of the Travel Industry Council. For outbound, it accounts for 73%. Regulatory cost only 58%. Cost only 28%. So in relation to registration fee, it is rather low. Well, we only charge 30 for a tour group of 40 people. So per head is only $7.50. So for an outbound group, say for example 3,300 to go to an Asian country, Southeast East Asian country, and for the levy of 0.15%, so per head is about 30 to 40 people. Each person is only about $5 compared to $7.50. That is compared to 75 cents. It is a huge difference. So we would like to use the approach of gradual increase to adjust the fees. First, after the enactment of the bills, we would like to adjust it to $100. And then in the long run, say for example, it will be comparable to the fees charged by outbound tour groups, but it will take over 10 years to reach that level. Well, if the regulatory cost drops, of course, the TIA will have the flexibility to adjust the fees charged. The most important thing is to break even. And we need to take into account where the regulatory cost goes. The registration fee is mainly on mainland inbound tour groups, but if there are other inbound tour groups with sustained problems, then we may consider charging a registration fee. But it depends on the actual situation. It's difficult for me to just answer you. Any chance that the registration fee of mainland inbound tour groups will be cancelled? Say, for example, the performance of such groups have improved, or it depends. It's very difficult for us to foresee what will happen in the future. We will take into account the expenditure, and we also need to take into account the financial situation of the TIA. Before we work out the best fee structure. If in the future the TIA doesn't have to spend much money on regulation, so then the fees may be cancelled. Is that right? You will take into account expenditure and revenue, right? Yes, and also the operation of the TIA. Next, Mr. Michael Look.
Chairman, well, I have 4 points I'd like to point out, and also to look at Annex 9, because I'm very concerned with the insurance issue, because they will need to buy work insurance for tour guides and escorts, and if there is not a clear guideline, then it would be very confusing. I'm not sure whether you would consider accepting our proposed amendment. Thank you, Mr. Look. Well, on Mr. Look's amendment proposals, we have received it and we would consider it accordingly. And when we move to the CSAs, then we are going to give you an overall response. Thank you. Mr. Look, any follow-up? Well, what are the considerations of the administration at this moment? Because all along, I feel that you are trying to ignore this matter. You're trying to evade it, and you don't really want to hear about comments, especially on insurance. This is actually a very simple matter. I don't know why the administration cannot take the initiative to look into this matter. Why can't you adopt a more proactive attitude? I always think that the government should take the initiative in taking proactive action to try to protect the interests of workers and employees. I don't think you're being very responsible right now. Assistant Deputy Commissioner, well, yes, if it is in relation to policy, then of course we would raise this issue. But I have already told you that we have acknowledged receipt of this, and we would consider these issues accordingly. Well, Mr. Lok, so there would be amendments proposed later on, and maybe we could reach out to stakeholders and to the industry to see whether we could come to a consensus on insurance. You have already made your point. The administration will consider it. Well, Chairman, the union of the industry really hope for insurance. We have tried to meet with the unions. Well, I'm helping the union reflect their views, and I hope the administration will also communicate well with the unions and the industry. Thank you. Thank you, Mr. Lok, for your comments. We are going to continue our communication with the industry. Thank you. Any follow-up? I will help the unions arrange a meeting with the administration. This is of utmost urgency. I know I'm being very long-winded, but there is such an urgency because there is a lack of protection for the tour guides right now. You really can't accept them having no insurance. Well, I'd like to follow up on the response paper. On the definition of opening premises to the public. Well, the Deputy Commissioner said it depends on the situation. Well, yes, of course you need to see whether there is any proof when there are patrolling officers. Well, but you also need to look at the business cards or some of the advertisements. There would usually be a business operation premise, and there might be a contact address. So if I put down contact address, then it will not be violation of this. And would it pose a problem? Do we need the circumstantial evidence? Well, actually, we're only talking about the travel agent license. It's very easy. You just need a copy to display it. But of course, we'd consider all the different circumstances. A business card cannot really be proof that a premise is open to the public. And so we really must consider the individual case. Let's say the travel agency said that it's not open to public, but basically it's a premise open to the public whereby public go to that premise for tour registration, but there is no display of travel agent license. So this is where a violation would be. All right, my last question is on display of information about tour group. Well, according to the TIC, well, if the tours are received by bus or vehicle, then there must be a display of information about the tour group. I see that from well, I just want to make this clear that this is not only limited to tour groups. Well, yes, I have explained it in the previous meeting. It seems that last time we only talked about tour groups, but this is not only limited to tour groups. It is something a licensed travel agent must do. All right, if there are no other questions in relation to this paper, then let us move on to clause-by-clause scrutiny. Thank you. Well, last time we finished 54. We can now move on to 55. So 55 is on the general provisions relating to licenses and licensees and the duty to comply with guidelines. So you can say that a licensee must comply with any guidelines, directives, or codes or conduct issued under Section 153 bracket 2 bracket K. So this is clause 55. If there are no questions, then let's move on to 56. 56, in relation to a correspondence address, we have looked into a property or travel agency 14, and we said that the licensee must have a correspondence address in Hong Kong to which communications of the authority may be sent. But as I have said earlier, in the past few meetings, we have mentioned that there are some licensed travel agencies that operate outside of Hong Kong, and because their business operations are not in Hong Kong, then we would not restrict them to have a correspondence address in Hong Kong. So this is what is stated in clause 56, that we are going to make some sort of amendments in relation to addresses outside of Hong Kong. Clause 57. So 27 bracket C, so we require the licensed tourist guide to inform the authority of any changes in the prescribed particulars of the guide in a prescribed way. And it is because that the TIA has considered that to consider whether the tourist guides or the tour escorts are still taking up their responsibilities. So I've already talked about Schedule 4. As to how they would inform the authority, there would be a prescribed way under subsidiary legislation, which would be stated by the TIA. So this is under 57, that there is a duty to inform authority of changes in prescribed particulars. Any questions? All right, please continue. All right, let us move on to clause 58. Clause 58. We have also looked into the travel Schedule 1 bracket 4 to see the definition of license or branch license, because we do have some amendments made to the license or branch license. So this is clause 58 on the particulars in the license or branch license. And then to 59, duplicate or license or branch licensee, and we're also looking into travel agents ordinance, and this is only procedures that we will follow in accordance with the travel agents ordinance. All right, if there is no other questions, then I will move on to clause 60 on offense relating to application for travel agent license or branch license. Well, this is already an existing legislation in chapter 218 48 1C under travel agents ordinance. So clause 60 said that a person commits an offense if the person provides any information that is false or misleading. So would you need to make amendments to the premises of business operations? Well, right now there is a term branch, but we're going to take it out later. So we would also make changes to the wording later on. All right, and then there's also on the penalty, and then moving on to clause 61. Clause 61 is on offense relating to application for tourist guide license or tour escort license, that if there is any false information or misleading information or document, that would also be an offense. So is this always the same with chapter 218? the tour guide or tour escort license was given out by the TIC before. So this is actually new legislation. But that was an administrative procedure from the TIC before. Yes, and then in future you would need a license. So it would become an offense if there is any false or misleading information. But in the past, there is no penalty for this. I mean, right now, yes, because the TIC does not have the authority or to set offenses. All right. Clause 62 on the effect of suspension. If a person's license is suspended under this ordinance, a license is not valid during the period of suspension, and we need to make clear of what we mean by suspension. Well, if there is suspension, of course, it would be because of a very serious incident. So you will need to make a decision. But it would be a temporary suspension. So who would be making the ultimate decision? Well, right now, there would be interpretations in the later clauses. And so we could give you a more detailed explanation later on when we reach those clauses. All right? Any questions about part 4? Let us move on to part 5 then. All right, so part 5 is in relation to the register, starting from clause 63. Clause 63, we also drew reference from the Chapter 6 of Travel Agents Ordinance that the authority must keep a register of licenses. Oh, this is why we have clause 63. 64 on the content of register. So in clause 64, we drew reference from Clause 2 of Travel Agents Ordinance and also from the Service Ordinance. And so this is a very detailed clause. Well, anything special other than it being more detailed? No. We just want to make sure that it is complete, and therefore we have listed out all the contents that we need on the register.
You see that the text is quite plain. It talks about the date of application, renewal, and also the address of the premises and the name of the licensee. 65. Sorry, the legal advisor has something to say. In relation to the register, and the administration said that they have taken reference from Property Management Ordinance. There is register will have to show the license number, which is absent here. If you refer to Roman 3, it says that the address of the premises specified in the license. Well, does it have to contain the correspondence address under clause 56? Because for overseas travel agents, they may not have an address in Hong Kong. About the license number, well, we haven't gone into such detail, but it's part of the register, so we will consider that. For premises, well, the correspondence address is very important, so we think that it should be included. Well, we will consider ways to try to put it in detail. Maybe you supplement it by way of an information paper. Yes. Anything else? No. Mr. Porter? It's now 64 to Roman 3b. 2b, other particulars. So what do you have in mind? Well, just now you say that for license number and the correspondence address. So what else would you require to be entered into the register? Or you want to be flexible, just add when it's necessary in the future? Thank you for the question. Well, for 64 bracket 2 bracket A, you'll find the content of the register. For B, any other particulars, it is to build in flexibility so that more particulars can be added in the future if necessary. Any questions? No. 65 is inspection and copying of register. This is also a very common provision under a licensing regime where a register is maintained. We have drawn reference from estate agents, ordinance, travel agents, guidelines, rules. It sets out the way of inspection and ways in which copying of the register can be done. Any other questions? No. Then we go to clause 66. Certified copies to be admissible as evidence, which means that particulars contained in the register as certified correct by the executive director. As I said, that we have taken reference from existing provisions, say for example, estate agent ordinance and also the travel agents regulations. The executive director of the TIA, is it going to be a post in the TIA? The executive director is a specified position referring to the head of administration of the TIA. So is the chief executive officer of the Travel Industry Council, that and the registrar. So the name will not be changed. No, we propose to name it executive director. So this is the name as set out in the law. Yes. Have you looked into it as to this name? We've also taken reference from the practice of other organizations. It is a name under the law. Well, when the TIA is set up, if they use this term executive director, then no problem. But it doesn't exclude the possibility that other names can be used. But on paper, it will have to be specified very clearly that under the law, whatever the post is named, it equals to executive director. And we think that executive director is an appropriate name for the head of the TIA. So you don't have to go to the LegCo as long as there is an explanatory paper saying that the post, whatever the name is, equals to the executive director. Right. For insurance authority, what name do they use? Is it the executive director? We will have to go back to check. Please maintain consistency so that you don't have to change it later. Please continue. We've completed part 6. Now is we've completed part 5. Now is part 6. Inspection and investigation. Division 1. Interpretation. It contains the interpretation of terms. Well, we may refer to this when we go into the relevant provisions. Division 2. Inspection. Clause 68 and Clause 69 aims at empowering the authority to appoint an inspector to inspect the register. Hold on. 69? 68 and 69. 69 is about the appointment of inspector to conduct an inspection. So 68 and 69 are looked at together. Clause 70 is about the power to enter and inspect. You find 4 subclauses. It's rather lengthy, so I will go into detail. For subclauses 1 and 2, it explains the scope of the inspection. That is, for licensed travel agents, the premises they maintain, the premises which the register is deposited. Well, it doesn't include domestic premises or premises occupied by inbound tour group participants. The scope also inspects vehicles and vessels used to transport participants. Inspectors may require the person in charge to produce license, identity card, and relevant information. When necessary, examination and inquiry can be made too. We have taken reference from the Travel Agents Ordinance. That is, Section 45, bracket 1, as well as Chinese Medicine Ordinance. That is in relation to subclauses 1 and 2. Any questions? I would like to ask. You talk about the books of account. The premises where books of account is kept. So where there is a warrant, they may enter. Yes, if it's domestic premises, then you will have to use clauses 75 and 76. So apart from home, inspectors can enter the other premises without a warrant. Right. So in relation to the premises where inspections are conducted, as you may be aware that there are a lot of mainland inbound tour groups. The mainland organizer may come in different shapes and forms. So can inspectors contact with mainland authorities to obtain more information to facilitate prosecution? Well, this is the laws of Hong Kong, so the scope of application is within Hong Kong. There has always been communication channels with the China National Tourism Administration. If we need information of individual tour operators or travel agents, we will establish communication channels. Who will be responsible for such inspections? Because only some people will have the power. Inspectors only deals with inspections done in Hong Kong. Who are those people where they can contact mainland authorities? Well, that's related to the administrative organization of the TIA. In relation to mainland inbound tour groups, I believe that there will be dedicated personnel to do it. It's just similar to the Travel Industry Council. Where there is an established channel of cooperation with mainland authorities. The Tourist Commission has communication channels with China National Tourism Administration as well as the Ministry for Tourism of various municipalities and provinces. So the TIC or the TIA will have ways to follow up with mainland authorities on issues related to regulation. Now we go to subclauses 3 and 4. That is in relation to information or document obtained from the inspection. The information and document is not limited to just visible, whatever form it is. It may be electronically stored. It's just like the Property Management Ordinance. You will find similar requirements. We have taken reference from similar provisions. 2A bracket 3 and C3 targets the operating environment of mainland inbound tour groups to ensure that the TIA can carry out inspections in premises where inbound tour groups stay. We hope that we can make use of Clause 70 to do something that the TIC could not. So that is Clause 70. Mr. Porter, I would like to clarify 72B. It says a vehicle. Vehicle or vessel. Vessel is just vessels, just ships, right? No, or boats, no aeroplanes, right? We now enter Division 3, Investigation. Clause 71, Complaints. A person may lodge a complaint that includes an unlicensed a licensee that is not suitable to hold a licensee's license, or whether it is someone who is licensed or unlicensed, and say for example someone who is supposed to be licensed with that but operates without one, then anyone can lodge a complaint. That's what it means. The complainant, if it is anonymous, would you entertain the complaint, or they will have to be named? We follow the same procedure when it comes to anonymous complaint. They will be dealt with. So when you receive a complaint and you think that it warrants actions to be taken, then you will entertain it. It depends on the evidence and the facts. If it is anonymous, it may be more difficult to follow up with the complainant. When we have the result of the investigation, we will not be able to contact the complainant when it's named to inform them of the result of the investigation. Thank you.
Any questions? All right, let us move on to Clause 72. 72 defines the authority's power to conduct investigation. So the authority can conduct an investigation if the authority has received a complaint under Section 71, or under bracket B, if it reasonably suspects that a person has contravened a requirement in this ordinance, a licensee is not suitable to hold the licensee's license, or the act or conduct of a licensee is contrary to the public interest or brings the travel industry of Hong Kong into disrepute, then the authority may conduct an investigation. Mr. Lee, Chairman, I would like to confirm or clarify that I have voiced my concerns about the industry, because the administration has said that after the TIA is set up, then you would have more power. So does it mean that when there are complaints, then if under Clause 72, if you suspect that a person has contravened, then can you really conduct an investigation? And if you're talking about licensee, does it include those those franchised stores that entertain inbound mainland tourists. Well, if a licensee is contrary to the public interest, that of course is a very important matter. But if you look at Roman numeral 1, it said a person has contributed a requirement in this ordinance, which includes all the policies made by the TIA. So previously, we have already listed out many actions that would be regulated under the ordinance, and any contravention of that would warrant an investigation. So there are 3 kinds of licensees here. One is the agent, second is the tourist guide, and third is the tour escort. We are also going to make reference from the TIC, and for shops that mainly cater to inbound mainland visitors, they would need to register, and there also would be regulations for them. Well, if the authority reasonably suspects that there is a problem, then we will be able to conduct an investigation. Any follow-up? So that means the licensees would not include those shops, but if a complaint is lodged by a member of the public, then it will fall under 72 bracket B bracket 1, that a person has contravened a requirement in this ordinance. So here you're not talking about a requirement by a licensee, right? Or how about the drivers? Well, let's say the drivers, after dropping off passengers, should not loiter on the roads and should park to nearby car parks. So would that include drivers as well? Well, right now the authority has not set up any regulations targeting tour group drivers. But drivers should already be regulated under the relevant road ordinances. The TIA, as an enforcement agency, would of course deal with these matters as deemed fit. Ms. Lee, I would start to limit Q&A to 5 minutes now. Thank you. Well, I understand that drivers face huge pressure. I'm not asking you to regulate drivers as of today, but right now you said that the registered shops are not regulated or are not considered licensees. But then there would be changes in accordance with times. Let's say in future, some of the people right now are not really regulated by the TIA. Or if in future you would need to regulate those people that are not regulated currently, such as drivers. Well, you said that the other road user ordinances have already regulated drivers, but if it is able to alleviate the situation, then I wouldn't be so worried about it. I'm not asking you to regulate drivers right now. I understand that they also face many difficulties in seeking parking. But in future, if there are other stakeholders that we believe should be regulated under the TIA, then what would you do? Mr. Lee, thank you, Ms. Lee, for your question. Well, you asked whether there would be other stakeholders that might need to be regulated in the future. Well, the registration plan is a very good way. The TIA will set up some administrative procedures to set up some administrative framework for those who may not be directly related to the tourist industry, yet some sort of measures should be adopted. So in accordance with your question, we would still have room for future improvement if needed. Well, under which part? Right now, we said that the authority may be able to set up some administrative procedures. We are talking about clause 55, that we could set up some guidelines or directives or codes of conduct. In the future, the TIA will be able to set such administrative measures. So you're talking about guidelines and directives in future for maybe drivers and shop owners. So there would not be a direct deterrent. Thank you, Chairman. I can supplement to this question. Yes, we are regulating agencies, but we believe that there is enough a deterrence. The TIA will have the authority to conduct investigation, and there would also be disciplinary proceedings, and there would also be penalties which could lead to a suspension of the travel license. We have to make sure that any arrangements would not affect the public or cause harassment. Therefore, as Mr. Lee said, we would set up with certain guidelines, directives for shops, and that could also have a regulatory effect. Well, a little bit of follow-up. You keep on saying that there would be a registration system. I understand that, but it said that if a person has contravened a requirement in this ordinance, then you may conduct an investigation. Would that be broad enough? Well, when we define the authority's power, that is later in the bill, we would include some definitions on some of the directives for shops, and so this would also be a requirement under this ordinance. So if we put the wording as for any person who has contravened a requirement, then it would have the necessary effect. Mr. Lok Song Hong. Thank you, Chairman. The shop registration system, is that mandatory? If a shop does not sign up or register, does it mean that the tour guides cannot bring tourists to those shops? Well, right now the registration system is for those inbound mainland tours who have already set out their particulars of their tour information. So they would already have registered. So they can only patronize the registered shops. Okay, so it is already shown clearly on the itinerary, but there is a big loophole, because it can list out all the particulars of the tour, yet bring the tourists to shops that have not registered. Well, if they set exorbitantly high prices or are unreasonable, then you cannot really regulate these shops, because they would actually have a negative impact on our reputation as a shopping paradise. Mr. Liu, perhaps you can tell us about the whole registration system, because people may be confused. They may think that the shops only register when they need to, because we are not familiar with your procedures. we don't know when the shops register. Well, this registration system has operated for quite some time, but there are still many of such so-called shops that are unscrupulous. So what can you do about it? Well, thank you, Chairman, and thank you, Mr. Lok, for your question. Well, we have already discussed how we can deal with this problem when we drew up the draft bill. The shop registration system deals with what Mr. Lok mentioned. There is no loophole, but the major problem here is when the TIC tries to regulate inbound mainland tours. The TIC does not have the authority to really regulate them. Well, for some of those shops that violate this, or when they're unscrupulous, or when the tours do not display their information, and when the tour guides do not bring their pass, then it will be difficult for the TIC to gather evidence. Therefore, the bill has tried to come up with new measures to target these problems. And when the TIA regulates inbound mainland tours, then they can also conduct investigations such as accompanying the tours to board the vehicles and to the shops. Of course, due to resources, we cannot accompany all the tour groups, but then there would be random inspections, and the TIA will have the regulatory means to actually penalize those violators. Thank you. Ms. Lee, well, Mr. Lok has asked about the registration system, which I would like to know more about. Well, Mr. Liu said there is a registration system. There needs to be advanced registration, and the mainland tour guides can only bring their tour groups to those shops. But have any shops been deregistered because of violation? Can you deregister any of the shops? Has there been such a case? These unscrupulous shops, they may sell fake goods or sell at exorbitant prices.
Yes, there are some registered shops that have been deregistered because of serious breaches. When you consider whether to deregister a shop, would you consider this as well? Say, for example, nuisance calls to the surrounding areas. Will you issue warning letters? Will you deregister them? Mr. Liu. Under existing laws and registration system, there are some limitations. They actually deal with forced shopping as well as low or nil tour group fees. If it involves nuisance cost to the neighborhood, as we've said that we need cooperation from various areas. It's not just the TIA alone that can deal with it. They have to work with the police, with district organizations, the restaurant or shops involved. Of course, district council, say the Kowloon City District Office is also involved. They have done something along the lines of tourist ambassador. They have adopted a multi-pronged approach to deal with nuisance. In cases where they know that there will be a lot of tours visiting the area. Interdepartmental meetings will be called to deal with the situation to ensure that nuisance will be kept to a minimum to the neighborhood. When it comes to proper regulation, well, we hope that the TIA will be set up as soon as possible so that it will have the power to deal with inbound tour groups breaking the regulation or laws. I'm aware of these measures mentioned by the Deputy Commissioner, where in the past you focus mainly on whether fake goods are sold. Well, if there are a lot of complaints, currently, where there are a lot of complaints, investigations may be conducted. The conclusion, one of them, may be deregistration, but you have evaded my question. I agree that with this bill, then there will be power. Whether is this deregistration, that is this registration system, and there are shops that have been deregistered. So would you add this to your proposed system? What do you mean? You mean before TIA is set up? Well, there is a transitional period. The TIA may make some rules to ask them to so that they can deal with district issues. So it's about the transitional period as well as the future. I have touched on this. Under current regulatory regime, there are some limitations and inadequacies of the TIC, one of which is that the TIC is not a statutory body, so it has limited power. When it comes to nuisance caused to a district, there are doubts whether they have a legal basis to do anything. And they don't have the power to enforce the law. In any event, the TIC has done a lot of things. Whether is nuisance caused to the district, letters have been issued to relevant parties. Mr. Michael Look. Thank you. The shop registration scheme, it's an administrative measure. You say that when this bill is endorsed, the TIA will have power to enforce the law. If that is the case, how come you don't incorporate the shop registration scheme into the law? Because shopping is a very important part of tourism. Right, it's just right behind accommodation and restaurants. The scheme is implemented by the TIA. Is there any room for improvement? Two groups take participants to a shop. It's a kind of a recommendation. In effect, and sometimes visitors end up buying something that is low quality or defective. I share the same feeling with Ms. Starry Lee. Ms. Lee's constituency comprises a lot of such shops. I am aware of it as well. Well, there are some unknown brands saying that they are famous chocolates or a famous watch shops or brands. So how can you improve this shop registration scheme? Say, for example, you will only allow those who sell quality goods to be registered. Well, there is no cost. Even if one breaks the law, you will lose the shop name. That's it. The TIC operates the shop registration scheme. It is effective. But when it comes to forced shopping as well as low or zero tour group fees, they have to be dealt with accordingly. If it's a mainland inbound tour group, well, it is done by way of an unauthorized travel agent. So there are provisions that deal with those receiving unauthorized travel agent. And there will also be inspections to ensure the operation of the travel agents is proper. There are also licensing conditions. Well, travel agents and escorts as well as guides can't be involved in forced shopping. Well, that is in relation to taking tour groups to designated shops where they receive large amounts of commission. The scheme itself is only a part of our many measures. There are merits for the TIC to operate it by way of an administrative measure, and there is a need to keep it the way it is. Of course, we have to make sure that shops are registered with the regulator. Tour agents will have to say that to state the address of the shops and when they will visit the shops to ensure that regulator can deal with it accordingly. I think I have answered Mr. Luk's question. And as to whether other factors is to be taken into account in the registration, well, it is an administrative measure. We will consult the trade to see how it can be improved when the TIA is set up. Can the scheme be written into the bill? That, conditions will have to be met. In the latter part of the bill, when we touch on TIA, you will see references to registered shops and the scheme. I think people are most concerned about the criteria. That is vis-a-vis travel agents and tourist guide. And they are all important stakeholders in relation to mainland inbound tour groups. It affects our image as well as the operating environment. When a travel agent is registered, the TIC may refuse the registration. But without any criteria or standard, well, you will conduct inspections to see if it's licensed, to see if it provides a safe environment, and that's it. In the future, there may be cases when inbound tour groups operate with shops. They make the registration, but when something happens, the shops and the travel agent simply close. And I do think you need to set down criteria or standards and have them all written into the law. And in the transitional period, where there may be still 2 years before the TIA is set up, you can talk to the TIC. There may not be inspection, but you can require shops to do certain things. Failure to do so may result in a deregistration. Well, this bill aims at enhancing Hong Kong's image as well as to enhance the effectiveness of regulation. I think you should do it as I suggested. Miss Lee, you're next. Oh, sorry, before that, Mr. Porter. We have to strike a balance. Whether you're an operator, escort, guide, the scope is wide. And if you want to include shops as well, what about restaurants that are unhygienic? Are you going to include them as well? What about transportation? Are you going to include that as well? I do understand why the administration wants to strike a balance. I also understand the difficulties they have in mind. For Section 146, there are some regulations. You mean those? Subsidiary legislations? Or there are others? That you say that, well, this includes all the regulations and guidelines. So that when Section 72 is contravened, they will be included in the scope of investigation. When it comes to the scope of regulation, we have to strike a balance, as Mr. Zhe said. Is section clause 153 bracket 2J. That is to put in place an administrative scheme to regulate shops that can be visited by travel agents. We say that this is an administrative measure. We can't write everything into the bill. We have to take into account the actual situation, especially when it comes to matters related to administration or operation. They are subject to change from time to time, and well, we won't be able to cater for every single situation in the bill. When administrative schemes are implemented and established, the trade will be consulted. When it comes to shop registrations and criteria, of course, we will include that when consultations are done with the trade.
Therefore, you are targeting licensed tour operators. Well, but if it is a third party recommended by the registered tour guides, then you're not directly targeting those violations. Am I right? Well, thank you, Mr. Zhe, for your question. Well, of course, we target at the first tier tour guides and, of course, the shops, registered shops. But in the administrative guidelines, much like what is being done under the TIC right now, that if there are violations and breaches and coerced shopping or violation of the trade goods ordinance, then the TIA will be able to request the shop to be delisted from the tour itinerary. And if the tour guides continue to bring tourists to the delisted shops, the TIA can conduct inspection, and if there are violations, then those tour groups or those tour guides could be suspended. Well, yes, but according to experience, since you're also targeting licensed tour guides and tour escorts, well, let's say they recommend a certain shop or a certain restaurant, then how do you regulate them? There may be different ways of doing that. Well, do you have to look into each shop? Or has any of those recommended restaurants been reprimanded by the Food and Health Bureau? Well, how do you set clear guidelines for this? Mr. Liu, well, yes, of course, we need to strike a balance. Now, it's of course a bit more difficult to deal with verbal recommendations than those in writing, but then the TIA will have the authority to conduct investigations. And for tour escorts, tourist guides, and agencies that force the tourists to go into those unscrupulous shops, then the TIA will have the authority to deal with these matters. But right now, we cannot have it cut across the board because it does depend on the individual situations. But we do have measures to regulate it. We want to still possess the flexibility to deal with inappropriate behavior and unscrupulous practices. All right, Mr. Zhe, if you would like to ask questions, please wait for your second round. Mr. Lee, Chairman, I agree with what you said, but then the administration has not given us a direct response on what to do during the transitional period. I understand Mr. Zhe's point of view. I'm not requesting expanding the scope of stakeholders to drivers. We really need regulation for the shops because there are many unscrupulous shops. But then your current mechanism right now cannot deal with these shops. I know it's very difficult for the Deputy Commissioner to give us a response today. Perhaps you should go back and consider it and try to look into why you cannot expand the scope of the registration scheme. And to reduce harassment to the vicinity. You cannot just say that you cannot do it right now and we have to wait for 2 years. I am not satisfied with this answer. Is it just not possible, or do you not want to deal with the trouble right now? I really need a paper in black and white to study it more clearly, because I really don't understand why you cannot expand the scope. Well, at least you can do that to new shops. Or can you try not to allow new registration in Kowloon City because there are already 90% shops in Kowloon City right now? Mr. Liu, well, I'm not going to repeat what I have said earlier. We would try our best and we would not be complacent during the transitional period. As I have said, stakeholders have been working hard in the past year and a half, and there are measures that have seen positive effects. So I will try to give you a response in the next meeting. Okay, so I will not follow up. Mr. Tse. On the past Sunday, I was trying to gain votes for a certain legislator, and in Causeway Bay, I think I saw more tourists than locals, and sometimes it's really a bit inconvenient for the locals. Well, we need to strike a balance. We want tourists, but we do want to strike a balance. I know that Kowloon City is a disastrous district. I know it's difficult for operators if we regulate traffic as well. We need to look into hygiene of restaurants and also integrity of shop owners, especially in areas with more tourist spots. I always see long lines waiting for the peak tram, and it's very inconvenient to the shops or people living nearby. But we can't really move the tram station. I understand that. But I don't think this bill should regulate everything in relation to travel. Otherwise, we would never hear the end of it. I'm not trying to disagree with Ms. Dari Lee, but these are my views. No, thank you, Mr. Tse. Well, yes, we do need to try to balance all interests when we set out new policies. We understand difficulties of shops, and we know that popular restaurants and shops would always see huge lines or crowds of people waiting outside. We understand that we do need to find a balance. Sometimes popular patronage may cause a nuisance. Well, we do need to work hard from all stakeholders to ensure the interests of all, including shop owners, tour operators, and the police. So we really need to work with the relevant departments, and we would try to enhance our coordination and cooperation. Well, even if there are huge crowds waiting outside a certain restaurant, we don't want people to block the streets. That there should be at least a way broad enough for other people to walk past. We understand that there's still a lot of work to be done. We can go back and discuss whether we could do more during the transitional period. And we would submit a paper in response to Ms. Dari Lee's question. Well, I think we should stop our discussion on this certain topic, and we can discuss it based on the paper we receive next time, because we don't know what the government response is. Would that be all right, Ms. Dari Lee? Well, thank you, Chairman. I also want to stop the discussion, but then I just want to respond to Mr. Tse. Well, I know it is very difficult to regulate all, but if we do not have a regulatory framework, then without a demerit system, and if it's only all based on a verbal warning and no enhancement or improvement measures are adopted, then there really is no solution to the nuisances. So I just hope we could do something. Or I'm not worrying about the operators, but the operators should be responsible because you're causing a nuisance to the community. I want to let Mr. Zhe know that many shops did not think that people control is their problem. But if you have attracted so many patrons, then you should at least have a mechanism to try to alleviate the crowds, much like the LLB registration. If you know that these registered shops will bring in loads and loads of tourists, it really is a nuisance to those who live nearby. Well, I'm not going to continue with this, but this is just my brief response to Mr. Zhe. All right, we could have a more concrete discussion when we get the paper next time. Mr. Chen Chi-chun, I understand and I agree with Ms. Starry Lee's concern. Right now, many of the problems have existed for a long time, but right now, the current legislation cannot come up with solutions. For example, on Java Road or North Point, we will see thousands of parking tickets every month, but the tour buses would just see this as a part of their cost. So we really cannot do anything to solve the problem. We need to look into what can be done. I understand we need to strike a balance, but we should not just surrender. I agree with Ms. Starry Lee's direction. Oh, Mr. Liu, you heard it? You heard him? Oh, please give us a paper next time. Oh, and on the transitional arrangements as well. All right? Well, we are not stopping all discussions here. We're just going to continue after we have received the paper. Let's continue now. All right, Clause 73 on the appointment of investigator, which is consistent with Clause 69 in the appointment of inspector. The authority may appoint any of its employees or any other person as an investigator to conduct an investigation under Section 72. Moving on to Clause 74. There are 6 subclauses, and we have looked into 21 of the Property Management Ordinance, and this talks about the power to obtain information and documents.
So it is consistent with the power of the proper management companies. That is, that the TIA may issue the investigator may issue notice to the person to ask for the provision of information document relating to the investigation, or to attend an interview to answer questions. And if it is not a licensee, well, say for example, other people, whether they operate without a license or operating as a guide or an escort without a pass. Say, for example, the TIA may require travel agents that are suspected to be insolvent to attend an interview and to provide information. That is just like the registrar of the travel agents registry. The TIA may also require operators who are suspected to be operating with unauthorized travel agents to provide information, say for example agreements signed. The TIA may also require travel agents to provide a written explanation when they're suspected of misleading travel agents' advertisements. powers may be exercised to require, say, for example, for the person being complained about to provide further information and to ask for people who are suspected to have impersonated as tour escorts or tourist guides to provide information. Any other questions? No. Then it's clauses 75 and clauses 75 and 76 in relation to warrants and power to enter and search. We have taken reference of the Section 41K of the Insurance Companies Amendment Ordinance 2015. That is in relation to power to enter, search, conduct investigations. It's just like any other provisions. When the TIA enters a premises to search it or to search vehicles or premises, the TIA will have to obtain a warrant beforehand. Well, when there is a prima facie case to suspect that a travel agent is operating without a license, an application may be made to a magistrate for a warrant to seize information related to the unlicensed operation. Mr. Porter, I would like to ask. Well, Section 21 of the Property Management Ordinance was taken into account when drafting this provision. When it comes to penalty against travel agents not cooperating to provide information, well, a summary conviction is 6 months. But is it the same level of penalty? When it comes to failure to provide information, failure to cooperate, is the penalty similar? You will find penalty in clauses 82 and 83. We have taken reference from penalty of the Travel Agents Ordinance. Say, for example, clause 83. It is without reasonable excuse, failure to comply with the requirement to provide information, then there may be imprisonment or fine on summary conviction or conviction on indictment. Thank you. The penalty level, are they similar? Yes. What about protection against the right against self-incrimination? I know that you require cooperation, but if there are other criminal offenses involved, is there a safety net? Say, for example, you force them to provide information that will divulge that another criminal offense unrelated to this bill is committed. Will there be protection against that? Well, there are no provisions touching on information provided relating to another criminal offense. Current protections will still be in place in accordance with just normal procedure of investigation. Say, for example, request the presence of a lawyer, right to silence, right to remain silent. We're not aware of any similar approach. Well, let's hear from law draftsman. We don't have anything to add. Mr. Lam, you don't have anything to add? No. Mr. Chair, perhaps we hear from the legal advisor first. relation to licensee or other persons and their rights under inspection, you will find information in clause 85. A person who is affected by an inspection will be protected under privileges and immunities that the person would have if the inspection were a proceeding in a court. Say, for example, the right to prevent self-incrimination. Say, for example, well, if the provision of certain information will affect my right, then so I can be protected and refuse to provide the information. The purpose of clause 85 is just like what Mr. Porter said. That means 74 is toothless. Because power under clause 85 can be exercised. But there is the power. It's just that, well, the person providing the information is protected. If the information provided, if it is related to another criminal offense, of course, a relevant law enforcement agency will conduct investigation. It's not like under clause 85 that offense will not be investigated into. Of course, I support protection. But if you compare 74 with 85, that means you can use 85 to hide. Say, well, under 74 you have to answer questions. But if another offense is involved, then 85 will kick in. But currently, 85 is rather wide. Can you try to strike a better balance so that 85 will not be used as a shield? We have taken reference of Travel Agents Ordinance. There are similar provisions, say for example, for estate agents and professional accountants. We will look into it before we reply to you. Give us an information paper then. This is a matter of common concern. I'd like to ask about circumstantial evidence. The registry or the council will only act upon receipt of a complaint. TIA will have a lot more power. What if, based on circumstantial evidence, an investigation is initiated? Say, for example, I see information on the internet and is suspected to be a unlicensed travel agent, or just simply information gleaned from a leaflet. Can they start an investigation? We were looking at clause 74. Under two circumstances, the TIA may conduct investigation. First, upon receipt of a complaint. Two, whether there is reasonable suspicion that the person may not hold a license or might have not acted in the interest of public interest. That deals with whether the authority has the power to conduct investigation. Thank you. Any questions? Well, maybe we will talk about it further after receiving your information paper. Now we move on to 77 and 78. We have taken reference from sections 56 and 57 of the Competition Ordinance. These two clauses is in relation to retention of property as well as disposal of the same. The provisions are the same as Competition Ordinance. if the TIA suspects that a travel agency is operating without a license and they have seized information, evidence, they have removed or retained property, then the TIA can, under Clause 77, retain the property. Say, for example, computers with information of transactions stored. And once it is confirmed that monies have been received by suspected unlicensed travel agents, then under Clause 78, upon the application to a magistrate, property may be disposed. That may include returning the property to the customer. We have 77 and 78 to cater for actual operation. The scope of disposal of property. Mr. Wong Ting Kwong. What about the priority of creditors? Say, for example, monies returned to customers. What is the order? Usually, who comes first? We have not catered for that. We will just make an application to the magistrate. We believe that it will be the same as the disposal of property in like any other cases. So, say for example, loans will have to be repaid to banks. Wages in arrears will have to be paid to employees, and what is left over will be apportioned to customers. Is that right? Yes, just like any other normal cases. When it comes to retention and disposal of property, well, you regulate escort guides, travel agents. What about shops? (77)(1) it states that will have to be it refers to property obtained under a warrant issued under Section 76, and it has to be in the necessary for the purpose of the investigation. So you see there is a limit stated in the warrant. Property may be retained only when it's related to an investigation or legal proceedings. So the scope is narrower.
So as long as the court will issue a warrant, then you can retain the property. Well, yes, we do need the agreement or approval of the magistrate. So we have to ensure that we have the necessary proceedings. Mr. Zhe, well, I'm not sure whether I really understand it correctly, because 77(1) said that if property is produced to an investigator or is obtained under a warrant, so that it also includes the property produced to an investigator, then the investigator may retain that property. Am I understanding this correctly? Mr. Lee? Well, 77(1), the first sentence, that the investigator can retain that property when we have received a warrant, and that it must be necessary for the purposes of the investigation. No, I'm not saying that. that all the you must go through the necessary proceedings. Well, the English is very clear, but the Chinese is not very clear. If the property is produced and investigated in response to requirement under this part, or is by warrant. Also, whenever there is an or, it means that it doesn't necessarily be by means of warrant. So property such as a shop or such as a vehicle or vessel can also be retained for investigation purposes. It can be very broad. Well, your understanding is correct. Well, maybe we are not very clear in our explanation right now. Mr. Zhe's meaning is that you do have the power to do that. Well, the most important thing is that if the TIA investigator needs to ask for property, then there must be a warrant issued. But if the property is produced after a request has been made, and this property can be seen as a property owned, and therefore it can also be retained. Well, if the information does not only include e-records and it might be assets, then how do you deal with this? Or would you warn the investigators that you are going to retain the property? Mr. Lee, if you look at the material obtained under Clause 74, this explains our power to obtain information and documents. We have not included valuable assets as asked by Mr. Zhe. Well, how about fake watches, or when you're investigating shops and you have a request to retain the watches, such as false watches, would you be able to retain those property as well? Mr. Lee, thank you for your question. If it involves assets whilst we are conducting investigation, then we would use a warrant to retain valuable property. This is what we mean by the drawing up of this clause. So I think that if it is a larger scale or more valuable property, then we would use a warrant. So can you actually make this more clear so that people will not have unnecessary worry? All right, please supplement this information before the next meeting. Any follow-up questions, Mr. Zhe? No. All right, next clause. Well, after 77, 78, our next clause is clause 79 to 81. And we have also looked into clause 29 of TAO, which is the prohibition on leaving Hong Kong. Simply put, under clause 79, subclause 1, 2, 3 states that an investigator may apply to a magistrate for an order prohibiting a person from leaving Hong Kong. And then subclause 4 to 7 talks about the arrangements made after the prohibition order is made, including the magistrate notifying the Director of Immigration and the Commissioner that the person is not permitted to leave Hong Kong. And then as soon as practicable, the investigation must also notify these persons that the subject person is permitted to leave Hong Kong. Oh, this is what is covered in clause 79 to clause 80. Clause 79. In clause 80 states the change to prohibition order by authority, that the authority may for good cause authorize the person to leave Hong Kong on one or more occasions. And clause 81, that if a subject person feels aggrieved by a prohibition order, then the person may appeal to the court of first instance against the order or decision. Any questions? Mr. Tse. Chairman, I want to clarify one point. Well, you said that this is similar to clause 29 of TAO, but I see that TAO only targets those in the tourist industry, but it seems that clause 79 is a bit broad. Does it include tourists as well? If the tourists refuse to cooperate or answer questions, can you prohibit them to leave Hong Kong? Well, that can happen. Well, if there is a fight or something like that, can you prohibit them in leaving Hong Kong? Well, the decision lies with the magistrate. So the TAO only regulates those related to the tourist industry. But now it seems that the scope has been broadened. We don't want to be misled. I think you need to clarify. Well, we're not talking about anybody. It must be someone who can assist with the investigation. And these would mainly be the licensees, such as the tour guides, the agency. So we're not talking about anybody here. We're talking about persons who are directly related with the investigation. And this would be subject to the magistrate's decision, which is already included in 79(2). The magistrate would only look at the legislation and can make an order against a person. Usually you know how the procedures are. The magistrate would put a signature once you have the proof. If you want to broaden the scope to assist in your investigation, then you should make it clear. Don't say that those relate to persons relevant to the investigation, because right now under the TAO only those in the tourist industry are regulated. Well, yes, if you look at clause 79, you can see that a bracket, that a subclause 3 said that the investigator's application must be well founded, and B, that it is in the public interest to ensure that the person does not leave Hong Kong, or if the person having left and returned to Hong Kong does not leave again without first assisting the investigator in relation to the investigation, then the magistrate can make an order against this person. And this person must be relevant to the investigation and be able to assist in the investigation. And we believe that in case this occasion arises, then there would be a flexibility. But it will need to go through the magistrate, as it would be the gatekeeper. Well, I understand that you're trying to balance a power here. I'm just not satisfied that it is clear enough. Has there been any cases that you have applied for prohibition in leaving Hong Kong under the TAO? I will defer this question to Mr. Au. There has been a case in which we tried to do so, but then the related person arranged for a meeting with us very soon, and we believe there was no need to make an order against this person. This is a very strong deterrent because during our investigation, the relevant person came to us of his own accordance to assist in our investigation. Thank you, Chairman. Well, would you tell your tourists that we do have this legislation in place? Have you tried to retain certain people to give evidence, but then you weren't able to do so? Has this happened before? Mr. Au? Thank you, Mr. Jie, for your question. Oh, Mr. Liu. Thank you, Chairman. What Mr. Au said is that we have already tried to do so before, and luckily because of such legislation, although that person has not yet been prohibited because he appeared on his own volition to assist in investigation. So there is a deterrent here, and I'm sure that that there is a effect to this clause. Of course, we are going to take caution when we apply this clause. We would need to have very well-founded evidence before we apply to the magistrate, and we are not going to casually use this clause. We will only need to apply for this prohibition when it is really necessary. I would like to follow up. I'm sorry because we time is up already. I would like to extend the meeting by 15 minutes if that is all right with everyone. All right, I'd like to follow up with this point. Well, Chairman, you have raised a very good point. Let's say there is a fight. Maybe the Commissioner has misunderstood my question. I'm asking about whether there have been some non-agents, related persons. You want those people, those tourists, to actually stay behind to help submit evidence, but then they refuse to do so because they wish to go back home. So has there been such cases? If there have been no such cases before, you're now suddenly expanding the scope. You have already explained that yes, it will be under the protection of the court, but then is there really such a need to really expand this scope to this level?
Thank you, Mr. Jie, for the question. We have to take into account different circumstances. It's difficult for us to say that, for all cases in the future, it will be related to those in the business. The investigation conducted by the TIA may involve different people. That's related to the operation of travel agents covering different areas. So apart from travel agents, there may be a need to involve other people. And if we set the scope narrow, then it will affect the effectiveness of the investigation. Just like Clause 79, there are checks and balances. So it will only be done when it's related to the investigation. We think that the scope is appropriate. However, we have heard members' views. The exercise of this power will be done very carefully. Next, Mr. Junius Ho. I don't mind the statutory power of the TIA, but I would like to know more about its operation, about its execution or exercise of this power. Well, a complaint is received, and then clauses 72 to 75 is involved. And well, if there is no cooperation, then you may stop that person from leaving the territory. But it's not like an investigation into a corruption case that they can detain you for 48 hours because there is a detention cell. So how do you detain these people? It's not just a case of fighting, because if he's fighting, then the police officers are involved, and the people are taken to the magistrate's court for the court to decide whether bail will be granted. So it's related to the power of a detained person. So you stop the person from leaving the territory. How do you detain the person? Where will you house that person? A hotel? What about the expenses incurred? I know what ICAC does because they have their own detention cell. But this is just a travel industry authority, not the ICAC. Well, if you detain people like the Gestapo, then it will tarnish the image of Hong Kong. Well, this is just to prohibit someone from leaving Hong Kong without detaining them. It's just that, well, they are prevented from leaving Hong Kong for a period of time. Of course, the period when they're prohibited from leaving the territory will be kept to a minimum. As soon as they provided the information, then it will be lifted. So I want to clarify that it has nothing to do with detention. It's just that, well, the person is asked to provide the information before leaving the territory. So how do you impose it? So, well, you can do it by having an making an application to the magistrate. Say someone has 3 travel documents. It's someone traveling under a Canadian passport, mainland passport, Singaporean passport, and a business travel document. Well, the person only surrenders 1 travel document while keeping the other 2. Well, if you stop someone from leaving the territory, you just detain the person. Well, the person may just maybe take a speedboat and leave from Taipei Bay. Thank you for the question. This is just about the prohibition order. There won't be any detention. And there won't be any detention of travel documents. When under 79, subclause 4 to 7, you will know the details. The magistrate may grant an order to stop the person from leaving the territory. Once such an order is made, the Director of Immigration and Commissioner of Police will be informed. And when the person tries to leave the territory at the border control point, then the Immigration Department and the police will execute the prohibition order. So it doesn't involve detention. of the person or their travel documents. If someone goes to Lowell, where there is a prohibition order, and the immigration officer will say that, well, there is a prohibition order, please just turn back, and no further action will be taken. Is that right? Right. Would that be effective, I wonder? That's a separate matter. Next, Mr. Wong Ting Kwong. The warrant of a magistrate is just to prohibit the person from leaving the territory. It's nothing to do with detention. Someone on the prohibition list will be asked to turn back. There's no power to detain that person. Is that right? The member's understanding is correct. We just would like the person to provide information and document. So the person will simply just turn around and stay in Hong Kong. Hong Kong is big. And if they try to avoid you while staying in Hong Kong, there's nothing you can do. Yes, thank you. I was going to say this. We'll ask the person to provide information and document. Under 74, this is mentioned. The investigator may require the person to provide information and document within and to attend an interview at the specified time and place and to answer questions. If the person fails to show up at the specified time and place, then it's a criminal offense. In 82-83, you will see how these are dealt with. That is, in relation to inspection or investigation, if someone impedes the power of investigation of the TIA, or if it's a case of failure to provide information or provision of false or misleading information, you will find how they are dealt with. No, I'm not concerned with that. What if it's a Hong Kong citizen? You may have contact information of the person. Well, what about visitors coming to Hong Kong? They cannot leave the territory. You said you just want to keep that to a minimum. In terms of what? Hours, days, weeks, months? And when the person is made to stay in Hong Kong, what about the expenditure incurred, say accommodation and food? It's not like the ICAC or the police, because the ICAC has a detention cell, and the police can send the person to Lai Chi Kok Reception Center. So you don't let me leave the territory. How do you deal with that? I have no money. Sleep in the street? Well, I think well, the member assumes that is someone who is only a visitor. Well, for parties that we investigate into, they are mainly Hong Kong citizens. If it involves visitors, well, we think the chance is quite small. Well, very often, I won't say that it's related to the mainland, but there will be cooperation with people outside Hong Kong. And when these people come to Hong Kong, do you investigate them? If you stop them from leaving the territory, then they say they have no money and then they throw a tantrum. And what are you going to do? This is just about striking a balance. I support you. But I'm concerned about actual operation. So don't say that I've gone to the extreme. You have to legislate a law that can be implemented. Mr. Sir, just 1 minute. But when it comes to 85, that is the privileges and immunities, because for 5B, it seems that, well, you will only allow them to leave when they have given you all the information to your satisfaction. But 85 says that you have the right not to answer questions. Perhaps that can be dealt with at the same time as well. Please give us an information paper next time. The next meeting will take place on the 11th of April, a Wednesday at 8:30 in the morning. Please attend. Thank you. Meeting adjourned.